Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Hello from Harrisburg still. Just responding to a really good question. It was about, and it's in response to the grid video share that came out today, kind of giving a summary of how, when you're 50 to 60, how those grids are actually, the main points of how they can influence your case, and give you an opportunity for a win that you might not have had previously. The question was, and it concerned a person who won their initial claim, say in their late 30s, and now they've had CDRs, everything's been fine. And now they're 50. Does the CDR diaring scheduling change when you hit 50? Anything like that? There is some narrative about how because after every CDR, they have to figure out what your next diary will be. So if you were on a 3-year diary, that might not last forever. Things can cause that to change. Maybe it'll become a 5-year or a 7-year. That could be things like the mere fact of turning 50, you now have a grid rule application that would be considered when you're going through a CDR, which affects, of course, the likelihood of improvement actually causing you to be able to be not disabled under the rules. So you have the age factor. You actually jump into a different set of rules. So there is that. But also your CDR can also show perhaps that the duration now that has been going on with a disabling condition or combination of conditions is now reflective of the fact that it probably will not improve in 3 years. Let's check again in 5 to 7 to see if medical technology has made any significant changes. So the longevity factor of being, I think, disabled, and they're determining that kind of disability, as reflected in your records back in the day, and currently, the way you respond perhaps to a 455 suggests that your diary date should be different. And again, that would mean going longer, probably not going shorter. So yeah, I think you can definitely change from a 1-year, 3-year to a 7-year, if the shoe fits. And obviously cases are very specific, impairments are very specific. So anyway, I hope that helps. I'll attach the grid rule video here in case you missed that, to which this question evolved from. Okay, have a great day, guys. Enjoy your week. Bye now. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Hello. Everybody's concerned about when they're going to get CDR'd and what can trigger a CDR. So let's go through it. There's a good page provided by the SSA. It's in the POMS, I believe. Let me just skim up. Yep, in the POMS. And by the way, POMS stands for Program Operations Manual System, POMS. We refer to it a lot. It kind of is the SSA staff's guidebook for how to handle things, ostensibly anyway. So we go there a lot. Okay, so this is DI 13001.005, events that may initiate a continuing disability review, CDR. Okay. I'm going to go through the list. I don't want this to get too lengthy, so if we have to go into more detail about a particular one, maybe that will be a different video. Okay, so the first one they talk about, this is the big obvious one. This is the one that pretty much everyone starts out with. Boom, when they win their claim and they become a beneficiary, they get assigned generally a medical review diary date. Well, it is a date, but usually it could be a year, 3 years. I've seen 18 months, 5 years, 7 years. The longer out your diary date is, and you can ask them what it is if it's not otherwise evident. the longer out it is, the less they expect you to improve in the interim, if at all. But because there are medical technologies, pharmaceutical technologies, even things that seem like they would not be improving over your lifetime, particularly for us oldie but goodies, they will generally have some sort of CDR date. Doesn't mean you're going to go through the whole 9 yards. Doesn't mean anything very burdensome is going to happen. But because we don't know, is why I always say be prepared for a CDR. If you just stick with the program all throughout, and make good habits, it won't be a big issue, in my opinion. Okay, so we got the medical review diary date. So that's something you can find out from the SSA, your field office, if you don't already know it. If you win at ALJ, sometimes the ALJ will have made a suggested date in there, and sometimes that will end up being the date, but not necessarily. Number 2, current evidence required. It is telling the staff, the SSA staff, to initiate a CDR if any kind of current medical or other report is needed to determine if the disability continues. Okay. Trial work period diary. And this is for Title II, Social Security disability only, not for SSI. A trial work period, TWP diary date is set at the first report of work. When that date matures and the individual is not protected from a medical review due to something else like a ticket to work and Work Initiatives Improvement Act, any of those items where you're not going to be looked at because of that particular program you're under. It kind of gives you a little reprieve so you can focus on your program. Okay, earnings record postings. This can be a trigger. Just like the end of a trial work period is a trigger that we just mentioned. They get alerts of records of Title II SSD beneficiaries with potentially, it says, uninvestigated substantial earnings after disability onset. They do go on to say that the earnings posted for the year of onset will normally not initiate a CDR unless, and it looks like they're talking about SSI is implicated. So, if you're, I'm just trying to read it real quick. If it looks like, and I think this would be like IRS reportings, employer reportings, that you're earning more than SGA, and I haven't investigated yet to see if you have any of the bases for bringing that under SGA, or always, if it's self-employment, business expenses, all that. Those earnings, the earnings record is going to likely trigger CDR. So while we love to go back to work part-time, do note that you better have your ducks in a row medically that you have been treating to show that, no, even though I've gone back to work part-time, I am not improved enough to work full-time. Voluntary reports. Oh, this is fun. This is when you yourself notifies the SSA that you have either recovered from your disability. This is rare. I don't see this often, although I have seen it. Or you've returned to work. So again, remember, returning to work is going to trigger a CDR, even part-time work, if you haven't otherwise been working part-time. Number 6 is vocational rehabilitation notification. So if you're involved officially with a VR service, you complete it and you're either working or the VR agency has indicated that you are now able to work, they will trigger a CDR. And generally, I think that would have to be once you're done with your TWP, trial work period. Number 7, this one's the doozy.
report from someone in a position to know. This is called the snitch or the vindictive revenge person who can fabricate. It says someone in a position to know of the individual's physical or mental condition tells us any of the following, and it appears the report could be substantially correct. The person reports that you are not disabled, and for some reason the SSA has reason to believe it to be substantially correct. How would they know it to be have reason to believe it is substantially correct? I'm thinking the person who did the reporting that you are no longer disabled or you're not disabled maybe submitted some sort of evidence with that statement. I'm not sure. B, the individual is not following prescribed treatment. Gee, what a rat out. And who would know that? Gosh, who would know what your prescribed treatment is other than your family? I don't know, just saying. Yeah, individual is not following prescribed treatment. So if someone reports that you're not doing what you're supposed to be doing, but as per your doctor, and obviously your doctor is not going to be reporting it to SSA, that's confidential. So that's interesting, right? How would that even get out there? Number C, letter C, the individual has returned to work. Mind you, working under the table is still working. It's also not legal to do that. I always say, if you're going to go back to work, be above board and stick to the rules. That's all you got to do. Pay your taxes, and keep it on the up and up. And that's the best way to stay safe when you continue to be disabled and are working. D, the individual is failing to follow the provisions of the Social Security Act. Well, that's a big old kitchen sink, isn't it? Huge blanket with that one. They're saying that, whatever, that's like, that covers the whole globe, really. The Social Security Act is immense, and they're saying that someone reports that you failed to do something you're supposed to do. So, or you're not following some sort of provision. So that could be anything. Let's say they say, oh, he's a felon and he's fleeing. Well, you know how like fleeing felons, I think, are not entitled to, cannot be entitled to, or are not eligible for benefits. Maybe it's something like that. Maybe the person left the country and is in a country to which the SSA cannot, I don't know, but that would be sending it to another country. That wouldn't really apply. I don't know. I think it's just a big old kitchen sink where they can say anything, right? The person calling it, any kind of rule, any kind of provision that you're not following that you're supposed to be. That's a real open-ended thing. 8, additional evidence received. If they receive medical or other evidence in connection with a new claim, this is interesting, okay? And this is because when we do a new, let's say we're on SSD or SSI. Let's say it's SSI, and we file for DAC because our parent, we were disabled for 22, our parent has now started collecting retirement or has passed or has become disabled themselves. We can file for DAC, disabled adult child benefits, on that parent's record. That helps us get off of SSI and at least onto some Social Security insurance benefits that our parent worked and paid for on our behalf. Okay, when you do that, you trigger a CDR of sorts, and they give you all sorts of other examples, like the childhood, that's the DAC, the childhood disability benefits, widow benefits. So any of these things, if medical evidence is sent in with it, that raises an issue as to whether disability continues. It could be you're going to your same old doctor, but suddenly you say you're working and they had no evidence that you're working. So whatever's in the evidence on any kind of new claim, if it triggers an alert for a CDR, that's what they're talking about, I believe. Vocational reexamination diary. A vocational reexamination diary is established when an individual is undergoing vocational therapy training or an educational program that may improve an individual's ability to work. Maturation of that vocational reexamination diary may initial a medical CDR. Generally, the diary period will be set for the length of the therapy training or educational program. So yeah, once you've vocationally increased your skill set, you might now be eligible for jobs that you weren't eligible before. And they might look at a medical CDR then. Number 10, extended period of eligibility. In Title II cases, a report of work activity. We talked about this before. Work activity, you start to work, and you're no longer in your trial work period. They can now do a CDR, and they're also going to be able to look at the kind of work you're doing, which they couldn't have done when you're in your trial work period, even if you were subject to a CDR for reasons other than that during your trial work period. Number 11, this is for Title 16, so I'm thinking this would be for SSI people. Earnings information that could cause a change in status or eligibility and may result in a medical CDR. All right, I'm not looking into these links here, so I'm not going to go into detail on that. I might do it after, and then I'll just do another video on what that is. Dual entitlement situations, evidence received during a CDR that results in cessation of one claim raises a continuing disability issue on any other benefit to which the individual may be entitled. Eesh. Okay, so that's always fun. Yeah. I mean, if you're entitled on more than one record but something in the medical evidence shows that your disability, it doesn't apply for your own work record. It may not apply on as a widow if you have those dual ways of collecting and they're going to start affecting those two. Okay. And so a CDR done in one is going to affect the other one. Title 16 redetermination, past due, on the medical improvement diary. This is number 13. Information concerning an individual's disability secured in response to specific questions during a Title 16 redetermination may indicating that a continuing disability issue exists. Wow. Yeah. Okay. I'm thinking that might be, not sure, it's kind of vague, but if you're in a Title 16 SSI situation and you're having a redetermination based on perhaps finances, redetermination, and information concerning your disability comes to light in response to specific questions during that redetermination, might then quote unquote indicate that a continuing disability issue exists and they might do a full-blown CDR. Okay. Work activity and the medical improvement expected diary. When there is a medical improvement expected diary, which is a lot of people, the individual who returns to work may have medical recovery that may prompt a medical CDR. That's kind of obvious. I mean, it seems like some of these seem to overlap, but yeah, I mean, if you're expected to medically improve and you do work activity, even if it's under SGA, they can still CDR you, obviously, because, going back to work shows that you might be better off than you were a year ago when you didn't go back to work. Right? Title 16 reinstatement, past due, medical improvement, expected diary. Initiate, it's telling the people to initiate a CDR when the Title 16 recipient, again, SSI, requests reinstatement following a period of suspension for non-disability reasons. Okay, so you're booted off of SSI for non-disability reasons. Perhaps it's due to working income or resources. Maybe you inherited something. You were gifted something that put your resources above what you can have to get SSI. When you ask for it to be reinstated because now you'll no longer have those excess resources. And that's just an example. You're gonna have a CDR. So I always say, don't poke the bear if you can at all help it. Keep the benefits continuing. Do other things to prevent them from discontinuing, such as, like if you inherit, try to get it into a trust perhaps, or spend it in a permitted way that's going to help your future. Those good spend downs, not wasteful spend downs. Also under that same number 15 is initiate a CDR when the SSI recipient, for the SSI recipient, if there is a past due medical improvement expected diary on the record. Yeah, that kind of is obvious. If you're supposed to have if you're supposed to have a CDR, basically a medical review diary date, and it's already expired, you know, like they were behind, which they often are due to understaffing. They're saying under number 15. So that was under, say, number 1. Under number 15, it says, hey, if initiate a CDR if you were supposed to before. That's what that's saying to me. So go figure. And the last one is the federal courts may require CDR action. I don't even know where that would be. I don't really deal with the federal court. Federal courts may also require CDR action or review of CDR cases. Okay. That's something outside of your control, it sounds to me. So anywho, yeah, that's, I don't even know what that is. But apparently it happens. So those are the 16 things noted on this page. I am going to save this page for you and put it down in the comments if you want to look at them. And again, it's called evidence that may initiate a CDR, not that will. So keeps us all more anxious than we already were, right? Anyway, thought I'd share that. Talk to you guys later. Bye-bye now.